Welcome, everybody. I hope you can hear me. This is a webinar on academic freedom basics. I'm Greg Scholtz. I'm the director of the AAUP's Department of Academic Freedom, Tenure, and Governance. With me today is Nick Fleisher, who is a professor of linguistics at the University of Wisconsin, Milwaukee. Nick was co-chair of our recent special committee on the North Carolina system, and he is a new member of AAUP's Committee A on Academic Freedom and Tenure. Also with us today is Mike DeCesar. Mike is professor of sociology at Merrimack College in Massachusetts. He's currently on leave from his position to serve as a senior program officer at the AAUP in our department. Mike is here to help handle questions in the Q&A box at the bottom of your screen. Before we begin, I want to note that the original version of this presentation was put together by our colleague York Tita and University of Nebraska AAUP activist Julia Schleck. So without further ado, Nick Fleisher is going to start us off.
Okay, thank you, Greg. Thanks everyone for coming today. So there's a little outline on our next slide here just of where we're going. We're going to start with some basics on general considerations about academic freedom. We'll compare it to First Amendment protected free speech. Then we will go into some of the details of the AAUP's 1940 statement on academic freedom and tenure, which is kind of the foundational document in this area that's been adopted by just about every scholarly society under the sun over the years. And we'll go through some of the core freedoms outlined in that statement and in the kind of 1970 further interpretation of that statement. So to get going with the basics of academic freedom, so here's a quote from Arthur Lovejoy about this. Academic freedom is the freedom of teachers and researchers to investigate the problems of their discipline, to follow their investigation where the facts may lead, without fear or favor, without interference from university officials or political officials or ecclesiastical authority, as it's put in this quote, depending on the kind of institution that may be in question. Essentially, right, it's a kind of grant of scholarly independence and authority to follow the facts, follow the investigation where they may lead, with a kind of presumption of professional and scholarly competence there, right? So academic freedom does not let you do just anything at all, but short of breaches of scholarly competence or professional ethics, this is meant to be a quite broad protection for scholars, for teachers and researchers to conduct their research in a professional way. Academic freedom is conceived this way as something that is designed to be for the common good. So the idea is that through these protections, scholars can make discoveries, can arrive at new interpretations for the areas of their subject matter that will presumably be of benefit for everyone, right? And that these are the conditions that we need in order to do that kind of work. So it's not just for the good of the scholar, it's not just for the good of the institution. The idea is that this kind of research that we are engaged in higher ed is something that has the common good and the public good in mind, ultimately. And so the protections of academic freedom are there in order to kind of safeguard and nurture those efforts that go into the public good. Part of the practice of this and part of what's contained in the 1940 statement and also in the AAUP's recommended institutional regulations is this notion of self-regulation of the faculty. So there, the way that this is often put in AAUP documents is that the faculty have primary responsibility in certain areas, and those include things like curriculum, but also in the area of academic freedom. This is something where faculty and peers at other institutions are the ones who make determinations and make judgments about scholarly quality, and about whether any potential breaches of ethics or things like that might be going on. And so we have some quotes here. One from the I guess both of these are from the 1915 Declaration about essentially the independence of faculty, and the idea that faculty are sort of not like other kinds of employees, in the sense that their work and the kind of public good towards which it is oriented call for this greater kind of freedom in their professional work. And so we've got some quotes here kind of putting this in nice language, right? So like the second one, university teachers should be understood to be no more subject to the control of the trustees than are judges subject to the control of the president with respect to their decisions, right? So there's a kind of broad independence. I mean, this is an explicit kind of separation of powers type of language that we have here in the 1915 Declaration. And these are analogies. They're not exact in terms of their respective structures, right? But the idea is that the relationship between university teachers and researchers and those who appoint them is different from the ordinary kind of relationship between boss and employee, right? And I mean, many of you maybe have had this kind of interaction with with friends or colleagues who work outside of academia, where they there's a sense in which you don't exactly have a boss in the way that many people do. Okay. This self-regulation of the faculty, this independence, is in the way that this is enacted, right? Is through employment protections and principally tenure, right? So the tenure system is contemplated as a kind of mechanism for safeguarding academic freedom, right? That is the point of tenure. It's to create the employment conditions under which academic freedom can flourish and indeed just exist. So we have some language from the 1940 statement here, defining tenure as an indefinite appointment, terminable only for cause, right? So I'm sure you're familiar with the standard kind of criticism of tenure, at least one of them, which is that it's a job for life. And you can do whatever you want, right? Which has never really been true. Right, tenured appointments are terminable for cause, right? If you act egregiously in one way or another, you don't necessarily get to keep your job. But the idea is that tenured appointments are the kind of set of employment conditions that enable academic freedom to exist. And so in the AUP's recommended institutional regulations as well, there's the AAUP really only recognizes tenured appointments and probationary appointments that are leading towards something like tenure, and that is for the purpose of ensuring that all instructors in higher education have academic freedom and have the employment conditions that make it possible. Okay, if we move on to the next slide. Okay, at least here we are. So this is further on this point about academic due process. So part and parcel of these protections is the idea that if there is going to be some kind of termination proceeding, that that there be due process involved in it, right? That these kinds of appointments are not terminable just at the discretion of the institution or the administration, but that there be involvement of faculty peers, right, an elected faculty body that would hear the case or hear evidence, and that the the person with the appointment who is going through this process would have the chance to have hearing, right, to present evidence in their defense if they wish, and so forth, right? So this is another one of these protections that is essential to ensuring that academic freedom can survive, right, and can exist at an institution. If we think about academic freedom and compare it to something like First Amendment protected free speech, which is sometimes done, we will see some differences, some important differences between the two. And there's some overlap, especially at public institutions. So there are some kind of First Amendment type protections for academic freedom at public institutions, but academic freedom is not the same as First Amendment protected speech. They're kind of developed separately. They exist in different kind of legal spheres, and they are sort of targeted at different things. The AUP's attitude towards academic freedom is that it's a professional right, subject to certain kinds of limitations, and it's the purpose of it is to enable teaching and research for the public good, for the common good, along the lines that we've been talking about. And that is, of course, quite different from, First Amendment protected speech, which is, where the First Amendment kind of protects individuals from, from government. Right. So here's a quote from Robert Post on this topic about academic freedom as a professional freedom. Right, so I'll read some of this for you, right? It's not to liberate individual professors from all forms of institutional regulation, but rather to ensure that faculty within the university are free to engage in the professionally competent forms of inquiry and teaching that are necessary for the realization of the social purposes of the university. And in this sense, academic freedom is a professional freedom, right? So this, again, it's oriented towards teaching and research as a public good. And so it's kind of instrumental towards that goal, right? Towards creating the conditions for that kind of research and teaching to flourish and making sure that academic freedom can exist on campus. Back to comparing this with free speech, it's not the same thing, right? If, in linguistics, we would say that free speech as a model both overpredicts and underpredicts what actually, academic freedom is about. And this is because on the one hand, academic freedom is contemplated not just for public entities, but also for private institutions, but also because academic freedom doesn't protect every kind of speech, right? So it's simply not quite the same kind of thing, and so it's of limited utility as a model for understanding what academic freedom is about. And there's one more slide on this about academic freedom being both broader and narrower than free speech protected under the First Amendment. Right, broader in the sense that it, at least in one sense, that it protects speech on private campuses, and narrower because it does not protect all the kinds of speech that are protected under the First Amendment. Okay. So with those preliminaries out of the way, I'm going to turn things over to Greg to begin our discussion of the AAUP's 1940 statement. And Greg, you are muted.
Thank you, Nick, for telling me that I was muted. Yes, the 1940 statement on academic freedom and tenure is not the AAUP's best policy document, but it is the AAUP's most important policy document. And the reason that it's the most important policy document is that it represents a consensus reached in American higher education about academic freedom and the relationship of tenure to academic freedom. That formulation, that consensus was reached in 1940 by the AAUP and what is now called the American Association of Colleges and Universities. After many years of discussion among many organizations of administrators, trustees, faculty. The 1940 statement has been endorsed by more than 250 scholarly societies and other sorts of higher education organizations. And it has been incorporated in hundreds of faculty handbooks and collective bargaining agreements. This graph here comes from a survey that was published in 2020 by our colleague York Tita, the director of our AUP's Department of Research. 217 four-year institutions, and it indicates that around 70% of all institutions of higher education incorporate academic freedom language from the 1940 statement. Although about 20%, that's the light blue, do so without attribution. In other words, as I said, the understanding of academic freedom and tenure in US higher education comes predominantly, if not exclusively, from the 1940 statement. The structure of the 1940 statement is in 6 parts. There's a head note, which talks about its history, introduction, which gives a brief rationale for academic freedom and tenure, and then a section, 3 paragraphs on academic freedom. This is the section that's most frequently included in handbooks or collective bargaining agreements without other parts of the statement. The section on academic tenure, which we're not going to talk about much today. And then there are notes, both from 1940 and from 1970. And then the endorsements I mentioned earlier follow. Oops. The introduction says this about academic freedom. Institutions of higher education are conducted for the common good, which Nick referred to earlier, and not to further the interests of either the individual, teacher, or the institution as a whole. Higher education is not an end in itself. It exists to serve society. Academic freedom in higher education serves the common good by advancing the free search for truth and its free exposition. The short section in academic freedom, as I said, it consists of 3 parts. Talks about the 3 constitutive elements of academic freedom: research, teaching, and extramural speech. The definition is remarkable for its brevity and generality, which makes it susceptible to further elaboration and development, which is why the AAUP has issued scores of subsequent documents that derive from the 1940 statement and that further refine the meaning of academic freedom. Its skeletal nature may also make it more palatable. That is, if it was too specific, it might have given those who would have objected to adopting a statement in academic freedom more to object to. Interesting. So when you interpret the 1940 statement, what sorts of material is available to you? Well, the material available is material that both looks forward and looks backward. The AAUP's greatest document in my opinion, is the 1915 Declaration of Principles in Academic Freedom and Academic Tenure. Even though it preceded and obviously inspired the 1940 statement, the 1915 Declaration can be used to interpret the 1940, as can the 1940's immediate predecessor, this next statement here, the 1925 Conference Statement, which was another attempt to reach a consensus on academic freedom by numerous higher education organizations, mainly organizations of presidents and trustees. But most of the further refinement of the AAUP's understanding of academic freedom has been the result of its hundreds of reports of investigations and subsequent statements and reports derived from the 1940 statement. This wealth of commentary adds a great deal of richness, which is an argument for faculties and institutions using the 1940 statement in their handbooks and collective bargaining agreements rather than some other language, because if the 1940 statement is there, you have a rich wealth of other interpretation, other meanings upon which to draw, other commentary upon which to draw. So the first freedom this 1940 statement talks about is that of research. Teachers are entitled to full freedom in research and in the publication of results, which is followed by a qualification, as all these freedoms are. A fairly I would say this, I would say of the areas that academic freedom is designed, it's supposed to protect, the one about which, this is the one about which the staff at the AAUP, which handles complaints about violations of academic freedom, this is the one we receive the fewest complaints about. We seldom hear from faculty members who complain about their academic freedom and research being infringed upon. As noted here, it's a common misconception that academic freedom is primarily about or only about research. A misperception reinforced by the tying the award of tenure based on research accomplishments and by appointing contingent faculty members to teaching only positions, i.e., if you're only teaching, you don't need academic freedom, and therefore you don't need tenure. This is not consistent with the AAUP's understanding of academic freedom. Academic freedom means freedom in the classroom. Teachers are entitled to freedom in the classroom in discussing their subject, but they should be another qualification. Now, this is a good example of further interpretation, further refinement. So it says they should be careful not to introduce into their teaching controversial matter which has no relation to their subject. So what do you think administrators stress when they see this quote? They stress controversial matter. In other words, it's your academic freedom doesn't protect you from introducing controversial topics in your class, which is of course absurd. So further statements on this, including one that's attached to the 1940 statement, the 1970 interpretive comment, points out that this passage serves to underscore the need for teachers to avoid persistently intruding material which has no relation to their subject. And in 2007, in Freedom in the Classroom, Committee A wrote, so long as an instructor's allusions provoke genuine debate and learning that is germane to the subject matter, they are protected. So the key word here is germane, relevant. The AAUP is not against controversial. In fact, just where the genuine debate comes in here, it's against faculty members. Academic freedom does not protect faculty members who consistently intrude material irrelevant to their course into the classroom. That is controversial. So Nick talked earlier about the fact that academic freedom is not absolute, that it doesn't mean that faculty members can do and say whatever they want. It's limited in a number of ways. It does not, for example, protect incompetence, does not protect lousy teaching or research. It does not protect misconduct, plagiarism, harassment, abusive behavior. With respect to teaching, it's also restricted in situations such as the one described here. That's a situation in which a department or another group of faculty members teaches a course together, a multi-section course, in which some material is shared by agreement between the group. This is from Freedom to Teach, which was published in 2013, Statement of Committee A. That shared responsibility involves a shared academic freedom, which, forgive the word, trumps the freedom of an individual faculty member to assign a textbook that he or she alone considers satisfactory. So while there's latitude in teaching a multi-section course, there are certain elements of it that do not give the faculty member freedom to do whatever he or she wants. And that brings us to extramural speech, which is where Nick takes over once again.
Okay, thank you. Yeah, so, and this I think goes to a question that was posed in the Q&A earlier about how far academic freedom protects people outside of the university setting, outside of the classroom. And this is what the language about extramural speech is explicitly about. So on the, if we jump to the next slide here, there's a quote from Walter Metzger describing this as the distinctively American contribution to the theory of academic freedom. And perhaps more to the point, this is the most controversial aspect of the 1940 statement. It's the one that generates, probably the most conflict, the most controversies, and it's the one that also is, I would say, alongside teaching matters, the one that causes conflict the most often, right? So as Greg mentioned earlier, relatively few cases come to the AAUP involving violations of academic freedom in research. But what we have seen in the recent environment is much more proposed restrictions from state governments and similar kinds of bodies on what instructors are allowed to teach, right? Directly, sort of delving directly into curriculum, which the AAUP views as the faculty's primary responsibility and part of the core academic freedom in teaching. But then also controversies generated by statements made by faculty members outside of the university setting in the extramural setting. So the statement language is on the next slide here. And this says, when university teachers speak or write as citizens, they should be free from institutional censorship or discipline. And then it goes on to say, to kind of say that faculty members also have a responsibility to demonstrate that they're not speaking for the institution, to show appropriate restraint, and so on. And there are some interpretive comments that came later in the 1970 comments on the following slide that put that in a bit more context and kind of emphasize that in these kinds of cases, any kind of hearing or any kind of dismissal procedure that might arise from something that a faculty member says in an extramural setting needs to be heard by an elected faculty committee. And the quote here from the interpretive comments in 1970 is, a faculty member's expression of opinion as a citizen cannot constitute grounds for dismissal unless it clearly demonstrates the faculty member's unfitness for his or her position. And so this is, I think, at least the way I understand this, this is meant to kind of balance out what might have been seen as, comments in the 19 or language in the 1940 statement that was kind of presumed or placed a bit more of a burden on the faculty member to distance themselves and from speaking for the institution than maybe turned out to be appropriate. So this is obviously an area where lots of controversies come up, right? Especially with so many more venues and possibilities for people to speak in extramural settings now than there ever have been before. But as far as the 1940 statement is concerned, and as far as the AAUP is concerned, faculty members retain their right to speak as citizens on matters of public concern, and they retain their academic freedom in doing so. And so there are, the AAUP will consider it a violation of an instructor's academic freedom if a university takes action against them on the basis of something they've said in an extramural setting that's protected in this way, right? Subject to the various kinds of, limitations that we've talked about earlier, right? It can't be something that demonstrates, manifest unfitness for the job. This is from a 1949 investigation, this quote here. This is, I think, kind of on the way towards those 1970 comments about the duty to distance yourself from the education, right? So if you're a university professor and you're at some local event, you don't have to, warrant that you're not speaking on behalf of your employer if you're just at a bake sale or whatever. Okay, and this brings us back to the matter of intramural speech, and I'll turn things back over to Greg for this.
Thank you, Nick. So there's four constitutive elements of academic freedom: academic freedom in teaching, academic freedom in research, academic freedom in extramural speech or extramural utterance, and finally, academic freedom in intramural speech or intramural utterance. So even though many, if not most, of the AAUP's investigations, including prior to 1940, concern faculty members fired for speech critical of their own institutions, administrations, and policies, the 1940 statement says nothing explicitly about academic freedom in intramural speech. It doesn't say anything explicitly about speech by faculty members in their capacities as citizens of an academic institution. As a result, the AAUP has issued guidance, especially in response to a Supreme Court ruling called Garcetti v. Ceballos, advising faculty members, especially at public institutions, to incorporate language in their faculty handbooks or collective bargaining agreements that specifically says that academic freedom includes the freedom to speak intramurally without fear or favor. As the report is cited in the footnote there, protecting an independent faculty voice, academic freedom after Garcetti v. Ceballos. As that report recommends, it recommends several different versions of language that one can put in your CBA or faculty handbook. But one of them is this, that academic freedom includes the right to, quote, address any matter of institutional policy or action, whether or not as a member of an agency of institutional governance. That is, you don't have to be on the faculty council to criticize the administration's latest budget proposal or the building of an athletic center. It's worth noting here that academic freedom is dependent on faculty members exercising their faculty governance role. That is, as we like to say, academic freedom and faculty governance are inextricably linked. If you want academic freedom to thrive on your campus, then faculty members have to accept their responsibility in areas like faculty personnel, the granting of tenure, being involved in dismissal actions and so forth, as well as serving on the curriculum and academic policies committee. The locus classicus on this question of academic freedom and governance is the statement cited at the bottom there on the relationship of faculty governance to academic freedom, which was issued in 1994. A sound system of institutional governance is a necessary condition for the protection of faculty rights, and therefore for the most productive exercise of essential faculty freedoms. Conversely, the protection of academic freedom is a prerequisite for the practice of governance unhampered by fear of retribution. And here's where the quote is about, in sum, sound governance and exercise of academic freedom are closely connected, arguably inextricably linked. And with that quotation, we have come to the end of our webinar.